Hello everyone, a very good evening. Welcome to Oliveboard. This is the CAIIB Foundation for the June 2025 exam series for the BRBL paper. And here we are discussing all the units from all the modules and completing the chapters. We have already completed the first two modules, and right now we are in module C. All right, so let us begin. Today we have the unit 18E from the module C, which is the recovery of debts determined by tribunals and the miscellaneous provisions. So once the recovery certificate is passed by the tribunal, what is the procedure which is followed by them for the recovery? What are the modes of recovery available? Then is there any appeal that lies against the decision taken by the tribunal? What is the procedure for filing the appeal? All of these things we are going to discuss today. So make sure that you like the video. This is very important for your exam preparation. Also subscribe to the channel so that you do not miss any of these daily sessions. So let us start. First, in the section 25 of this act, it is clearly stated that when the recovery officer is receiving the copy of the recovery certificate, then what will happen? They will proceed to recover the amount which is specified. So the DRT, they're going to specify the amount which is to be recovered in the certificate, and what are the modes that are available to the appointed recovery officer for the same. They can by attachment and sale of the movable and immovable property of the defendants, or they can arrest the defendant and detention in prison, the appointment of a receiver for the management of the movable and the immovable properties, taking possession over any asset or property on which the security interest is created, and appointing a receiver and to sell the same, or any other mode of recovery which has been prescribed by the central government. So once the recovery officer, they receive the recovery certificate, right? So they can sell any property that is owned by the defendant. Also the arrest provision of the defendant, it will be have to be made keeping in view the Supreme Court decision that it should not contradict the values stated under Article 21, right? So it should not be against the fundamental rights which are available to the people of India. Then, if we talk about the validity of the recovery certificate, so we have also earlier discussed that once the recovery certificate is passed, then the defendant is debarred from raising any dispute before the recovery officer about the correctness of the amount specified in the certificate. They cannot say that the amount which is mentioned in the award is incorrect, it is high, or it is unfair. They cannot make any dispute about the amount which is specified. And the recovery officer is not going to entertain any objection which is raised by the defendant on any other ground, right? The only option which is available to the defendant is that they can file an appeal, but they cannot complain anything to the recovery officer. They are just carrying out their duties which are mentioned in the recovery certificate by the authority. Also, the presiding officer of the tribunal who has issued the recovery certificate, they will authorize, only they are authorized to withdraw the certificate. Also, to correct any clerical or mathematical error in the certificate. So the recovery officer is not going to entertain any objection. If there is any objection regarding regarding any mathematical error in the certificate or regarding the correctness of the certificate, then it will be dealt by the presiding officer of the tribunal. So any party, if they want to have a review of the order which is passed by the tribunal or which is given in the recovery certificate, on the ground that the error is apparent on the face of the record, it is right, clearly visible to the naked eye that there is an apparent error, a mathematical or a clerical error in the recovery certificate, then they can make the application for review within 60 days of passing the order or issuing the certificate. So when they receive the certificate within 60 days, they can file an application for review with the same tribunal. Along with the application, they will attach the affidavit verifying the contents. If there is any mathematical or clerical error, then the applicant will show that this is the correct information. This is the correct information which will be used for the review. Also, it is required that the opposite party is given a notice and a chance to be heard before the application is granted. Right? So, before the presiding officer makes any changes or any review, they will also give a chance to the opposite party to be heard. Right? So there can be the stay on the proceedings under the certificate, or it can be amended, or it can be withdrawn after the application for review has been made. So what is the procedure for that? Notwithstanding that a certificate had been issued to the recovery officer, even though the certificate has been issued to the recovery officer, still the presiding officer may grant time for the payment of the amount if the defendant makes a payment of not less than 25%. If on the very first day they make a down payment of 25%, then additional time will be provided to the defendant, and only after that time the recovery officer is going to continue with the proceedings, with the selling of the property. So, if the defendant makes a down payment of not less than 25% of the amount which is specified in the recovery certificate, and an unconditional undertaking that they will pay the balance within a reasonable time, so the presiding officer can put a temporary stay on the proceedings. So, this power is given to the presiding officer of the tribunal. So, yes, they are going to stay on the proceedings until the expiry of the time so granted, and the defendant they agree to pay the specified amount in the recovery certificate. If however they commit any default in the payment, then the proceedings will continue, and the stay on the recovery proceedings shall be withdrawn. All right, so all of this information the presiding officer will provide it to the recovery officer. There are also certain other modes of recovery which are allowed, which are prescribed by the government, central government, apart from the ones that we had discussed in the beginning. But again, it is upon the discretion of the central government and the tribunal. All right. Then appeal against the order of the recovery officer in the recovery certificate. The appeal shall not lie in the case stating that the amount which is mentioned in the recovery certificate is incorrect. The appeal will be there only if any third party is aggrieved by the order which is passed by the tribunal. Right? So the recovery officer is given powers under section 25 and 28 to recover the amount. The defendant cannot question the or they cannot dispute before the recovery officer about the correctness of the amount which is mentioned. However, when a recovery officer attaches and sells the property, it is possible that any third party that is having interest in such property may get affected. So, any person that is aggrieved by the order of the recovery officer, they may appeal within 30 days to the tribunal. So, this 30 days will be counted from the day that they receive the copy of the order. All right, when the copy of the order is issued to the person, then on receipt of the appeal, the tribunal has to hear the appellant and make the inquiries as it deem fit. Thereafter, making the inquiries, the order of the recovery officer may either be confirmed or modified or set aside. All right, so an appeal is preferred against the order of the recovery officer in this manner. All right. Then if we talk about the transfer of pending cases, in the very beginning, we discussed that the jurisdiction of the tribunal will start on the day it is established. The day it is established, not from the enactment of the act, but from the day a tribunal is established in a particular area. So, what if a case was started before the tribunal was set up and this case was under the civil court? Again, there can be two situations. Either the order has been passed by the civil court or the case is still pending in the civil court. So, what will happen here? So, the section 31 deals with the issue of transfer of the existing cases to the tribunals. So, every suit or other proceeding which is pending before any court, immediately before the date of the establishment of a tribunal, being a suit or proceeding, the cause of action whereon it is based, then if it had arisen after such establishment within the jurisdiction of such tribunal, it shall stand transferred on that date to such tribunal. So, if a case is pending, then it will be transferred to the DRT. All right. Only if the case is pending in a court and then a DRT is established in that area. So now the case will be transferred. It will now be under the jurisdiction of the tribunal. But it is very important to note that if there's a decree or order passed by any court before coming into operation the DRT Act and it is not yet executed, then the decree order may apply to the tribunal for the issue of the certificate. All right, so now what has happened? The award or the order is passed by the civil court. They have passed the decree, but it has not been executed. The order to sell the property has been given, but it has not been executed, it has not been started. Then the DRT will, the case will now be transferred to the DRT, but no fresh proceeding or trial will be taken. And on the basis of the order or the award, the recovery certificate will be created. So now the tribunal will have the responsibility of only issuing of the recovery certificate. There is no fresh trial or hearing in such cases, and the tribunal has to directly issue the recovery certificate, which is based on the decree of the civil court. Right? So, if the case is pending in the civil court and no order has been passed, then the DRT will take over the proceedings. But if the case is not pending, it has been completed, and an order or decree has been passed by the civil court, then only the execution of the order will be done by the tribunal. No fresh hearings or tribunals or proceedings or trials will be undertaken. These are the provisions. Then, if we talk about the protection of action taken in good faith, so any action which is taken by the central government, the presiding officer of a tribunal, or the chairperson of the appellate tribunal, or recovery officer, no suit will lie against these actions. So, when anything is done in good faith, then no suit, prosecution, or any proceeding shall lie against these entities. And this protection is given so that the authorities can function without fear as well as hindrances that the borrower otherwise can put. All right, so they are provided protection against any lawsuit or proceeding. So that is all in this chapter. We have completed all the important provisions, right? And we have also completed the DRT. We have completed the whole act, the Recovery of Debts and Bankruptcy Act of 1993. And starting tomorrow, we are going to start with the Insolvency and the Bankruptcy Code. So, if you want to prepare and if you want to join the CAIIB Super Elite plan, which is all in one plan, where you'll get live classes, mock tests, and notes, you can subscribe to the course and you can avail the benefit of the New Year Bash offer. So use the code HNY and avail 52% off on your CAIIB subscription. This offer ends on 9th of February, so make sure that you join the course before that. The classes have already started, the exam dates are out, and it is very important that you give 100% towards your preparation. So join the course and start today. Also, these videos, these sessions in which we are summarizing each and every chapter, these are happening on a daily basis on the YouTube channel of Oliveboard. So make sure that you subscribe to the channel, watch these videos on a daily basis. If you have any doubts, any queries, you can let me know in the comment section. Also, all the important updates till the date of your examination you'll find here itself on the YouTube channel. So make sure that you subscribe, and you can also find the link to download the PDF in the description box. Thank you so much for attending. I will see you again tomorrow with the next chapter. Till then, take care and all the best.